Coming up Sunday on The Attorney is going to be joined by Josh Wright of the firm Hollis Wright, talking about pregnancy discrimination, an issue that's pretty common, actually.
It is. You know, this is a topic that we have done in the past, a couple years ago, but there's been some legal changes. We're going to be talking about the Pregnancy Discrimination Act, and we're also going to be talking about the Family Medical Leave Act.
Okay.
Both those acts are applicable to assist individuals that are pregnant in the workplace. But one of the nice things is we're also going to be giving some good advice for employers. So if you're an employer and you're sitting on the couch on Sunday night, watch the show, because we're going to be giving some advice on things you can do and tricks of the trade to make sure that you comply with the law.
Yeah, there are some minefields as an employer you certainly want to avoid, and some rights you have as an employee. Join us on Sunday night. Josh Wright of the firm Hollis Wright. We'll see you Sunday night after the news. We'll see you then.
Sounds great.
See you then.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening, and thank you for joining us tonight. Our topic of conversation is pregnancy discrimination, when that bundle of joy creates a bundle of issues. We're going to get into that with a panel of experts. Would love for you to be a part of the conversation. Easy for you to do so. For the next half hour, we're going to have some information at the bottom of the screen where you can call, you can text, you can email, and a reminder that an attorney is standing by right now. So now's the opportunity for you to join the conversation, which is led by Josh Wright of the firm Hollis Wright.
Good to see you. Good to see you too. How you doing?
I'm doing good.
Good. Bundle of joy. That's a way to start the show.
That's normally what it is, right?
That's the way it's supposed to be.
Yeah, that's right.
Doesn't always work that way.
No,
you know,
true.
David, in pre-production, first of all, Heather Leonard's with us today. Heather is a law school classmate of mine. We traveled around the country doing national moot court competitions together. She's an incredible writer, just an awesome lawyer, and she has done shows like this for us in the past. She is an expert in this area, among other employment-related issues. So first of all, thank you for being on.
Happy to be here, thank you.
I can have you every week, because as I told David before the show, you can carry these shows without any problem. I can actually go to sleep and you can just handle the thing, which is a good thing.
We don't want that. I don't want to put you to
That's
sleep.
all right. We're going to be talking about pregnancy discrimination, and Heather really is an expert in this area. You know, there's some interesting statistics out there, one of which that we'll talk about today is 75% of all women will have an issue in their life where they are pregnant while employed. Those are some of the statistics we see. And so we're going to be talking about some of the protections that individuals that become pregnant and their spouses, their husbands, the protections they may have in the workplace to be able to make sure they have the same rights and responsibilities as everybody else would have in the workplace. So it's going to be an interesting topic, one that we've done before. But it's good to see you.
It is good.
I'm glad to have you here.
Glad to be here. Looking forward to this conversation.
That's right.
You know, talking to Heather before the show, one of the big changes was a Supreme Court ruling relative to exactly what we're going to be talking about. Help us kind of make sense of that.
Absolutely. Earlier this year, when the Supreme Court cases started coming out, there was a case against UPS that dealt with a pregnant employee. And UPS had a policy that people who had experienced on-the-job injuries, a work comp injury, if they had any short-term disabilities, would be accommodated. They would get light duty, time off, but they wouldn't be treated badly at work. They would work with those restrictions. However, they wouldn't provide the same type of accommodations for people who had restrictions or limitations that weren't related to an on-the-job injury. So what you were seeing is you might have somebody with a work comp injury who had a lifting restriction of no more than 20 pounds that the employer would accommodate. However, they wouldn't accommodate the same restriction for a pregnant employee, and as a result, the pregnant employee would lose their job. This case goes up before the Supreme Court, and the Supreme Court said, no, you can't do that. The Pregnancy Discrimination Act says you cannot treat a pregnant employee differently or worse than a non-pregnant employee. So if you're providing these type of accommodations for non-pregnant employees, people who had a work comp injury, you have to do this as well for pregnant employees.
There are some circumstances, though. Now, there's an 11th Circuit case, nurse HIV case. Do you remember
Correct.
that case? Talk a little bit about that, because that is, I mean, when you juxtapose those two cases together, that's a totally different result.
Exactly. The 11th Circuit case Josh is talking about involved a nurse who she found out she was pregnant, and she worked primarily with HIV positive patients. And her concern was, I don't want to expose my unborn child to the possibility of infection. And so she requested an accommodation of being moved to a different unit during the term of her pregnancy. And the 11th Circuit ultimately said, no, your employer isn't required to do that. That just because you're pregnant, you're not entitled to special treatment. So if your pregnancy keeps you from being able to do your job, the employer doesn't have to go and create something special for you in that. And so in that circumstance, they said, you know, if being pregnant, you're unable to do your job and work around HIV positive patients, we can't work with you there.
See, now you know why I say she can just carry the show. We could go through case after case after case. When we did this back in law school, she was the one that knew this stuff. Let's talk just for a second about this concept of, does an employer have to have an intent to discriminate through a practice, or can they argue we just didn't know the law and we didn't realize what we were doing to this person was inconsistent with the way we treat other employees? How does the law kind of handle that?
Ultimately, the law does operate on intent. We're what's called an employment at will state, which basically means in Alabama, your employer can hire or fire you for a good reason, bad reason, no reason at all. They can say, we don't like Auburn fans, get out. It's bad business, but not illegal. The exceptions come with the federal anti-discrimination laws, and this is one of those. And it says if your employer is using your pregnancy as a reason for a bad act, then that's illegal. So if the pregnancy motivates the decision, it's illegal. If there's a legitimate business reason or even a bad business reason, but it's not pregnancy, then it's not illegal. It does turn on motive.
How do you prove that motive in general terms in these cases?
That is what is challenging. The easiest case I had was a lady who was pregnant that was a security guard down at Fort Rucker, and they came to her, and thankfully she taped the meeting, and they said to her, the condition of you being pregnant is why we don't want you here. It looks bad for you to be on the front gate. There was no question there what their intent was. Yeah. They were using her pregnancy as a factor. But most of the time, you look at the circumstances, because someone's not going to come out and say, hey, I'm acting illegally. So what you do is you start comparing yourself to non-pregnant employees, and you say, David has a lifting restriction and you accommodated him. I have a lifting restriction and I'm pregnant and you're not. The only difference between us is my pregnancy, so the assumption then is that that's what's motivating the difference.
Now, I know that we've got the Pregnancy Discrimination Act, and then we have the Fair Labor Standard Laws, or what is it, the FMLA?
Family Medical Leave Act.
Okay. And so those would be applicable. But talk about this. If I'm an employer and I'm sitting on my couch right now and I'm thinking, are we doing something that's discriminatory to women that are pregnant at our place of business? Does it apply to everybody, each group, or does there have to be a certain number of employees? How does that work?
There are certain magic numbers that employers need to pay attention to. The first number is 5, that's workers' comp. The next key number is 15. This is where most of the federal anti-discrimination laws kick in, such as the Pregnancy Discrimination Act. Once you have 15 employees, these laws start to apply to you, and you need to evaluate your policies and practices to make sure that you're not treating people in those protected groups badly. The next key is 50 employees. The Family Medical Leave Act applies to employers with 50 or more employees. Jokingly, some people call it far more leave than anyone intended, because it gives you up to 12 weeks of unpaid leave a year. That's a quarter of the year. That's fairly substantial. And the size grows, the bigger the burden is on the employer. The larger the employer, it's assumed it can absorb and handle the burdens of these laws.
Let's talk also just about when it applies to somebody that is pregnant. Does it apply just if they're already employed? Does it apply when they're going through the hiring process? Can you not hire somebody that you know is pregnant because you know they're going to be out? Kind of explain that, because I think that's kind of a critical issue.
It applies to all aspects of the employment relationship. So if a woman is pregnant and applying for a job, an employer cannot refuse to hire her because she's pregnant.
Gotcha.
All right. Hey, let's step aside. Let's take a first break and we'll pick up right there whenever we get back. Our first break of the evening, and a reminder for you, an attorney standing by right now to speak with you. Call the number you see there, or text, also email. We try to make it easy for you to get in touch with us. Pass your questions along to us and we'll pass them on to our panel of experts. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back in to The Attorneys. Appreciate you being with us tonight. Would love to have you join the conversation talking about pregnancy discrimination. You can call, text, email that information displayed at the bottom of the screen throughout the program tonight. Josh?
Let's talk for a second. We just really touched on this with a point in the last segment, but I want to talk about males, married spouses that may have certain protections during the time that their wife is pregnant for a certain amount of leave that they can take. Tell us how that works.
And that's actually where the Family Medical Leave Act comes in. That when it was passed, that was one of its original intents, was to allow not only for women to be able to have maternity leave, but for fathers to be able to have the time off to experience the birth of their child and to bond with their child. And I actually have a case like that going right now where my client had applied for FMLA leave for the birth of his child, and they gave him 2 days off. Well, after that, his child started experiencing complications and is in the NICU. He goes to spend time with his child and his wife there, and the employer holds that time against him. We're arguing that that's time that should have been covered under the Family Medical Leave Act, because the intent of the act is to give the parent the time off to experience the birth or adoption of the child and to allow time for that initial bonding and recovery.
That's interesting. So the law actually protects. So in that case, for example, you may be able to argue that the time that was provided to him that was off time actually should have been on time.
Correct. And so the Family Medical Leave Act says he was entitled to have that time off from work, just as his wife would. And so that's one of the things people don't think about when they're looking at the Family Medical Leave Act. They assume it's leave for the birth of a child, it's only going to apply to the mother. But it also applies to the father, and a lot of fathers don't realize they have the right to take that time so that they can experience the bundle of joy that's coming into their family as well.
Now, the Family Medical Leave Act, the law that kind of surrounds that act has grown over time, I know. And I know you've been a big part of that in some of the cases you've had. The question I have related to that is this. As it relates to the act itself, is everybody eligible for it if you were employed? I know you mentioned 50 employees.
Right.
But are there other circumstances where you may not be eligible for that time?
It is. With every law, you have to look at its intended purpose. And the purpose of this law was to balance the needs of the family and the needs of the workplace. And so in order to be eligible, if you work for an employer that's covered, you first have to work there for 12 months. And 1,250 hours. So you basically have to be a full-time employee for that employer for a year. And that's to ensure that you basically don't come in and work for a month and then say, hey, I need to be gone for 3. That you've put in the time so that the workplace needs of having the work done is balanced against your need for the time off. Once you've met that criteria, you're eligible to take the leave, but you still have to have a qualifying condition. This isn't a law that's there for, I had a really bad cold or I stubbed my toe. It's for the birth of a child, the adoption of a child, or a serious medical condition is certified by a medical professional.
And you don't get paid for that time. You're guaranteed your position to be open, but you're not necessarily paid during that time, which is an interesting part of the law.
A question we have here kind of takes it a step back, and that is we have a question here. Someone applying for a job and they are pregnant. They just found out they are pregnant. Must they disclose that to their potential employer?
That's a good question.
They're not obligated to, and that's one of the big no-no questions. An employer shouldn't ask you, what are your family plans? Are you going to start a family? Are you pregnant? That shouldn't be asked, because that's not something they're allowed to consider. Right. So it shouldn't come up in the interview. But from a practical standpoint, it's not a bad idea to share it with the employer if it is relevant. If you know that you're going to be needing to take time off at some point, you don't want to just drop that in their lap later. So, good manners dictates you may want to share, but legally you're not obligated to.
Now, let's jump to a different topic for a second, and that is women who have impairments during pregnancy, all sorts of conditions that can happen during pregnancy. Does the law protect that? Can somebody apply, for example, for certain types of aid and help after they have that type of issue that comes up?
They can. A lot of times short-term disability benefits will kick in. A lot of women find that due to high blood pressure or other factors, they may have to go on to bed rest early and take leave earlier than anticipated. Those types of that type of leave is there. Some employers provide additional emergency leave. Again, it goes back to look for how would this employer treat non-pregnant employees if they experienced a period of incapacity. How would they treat somebody who might have had a heart attack? How would they treat somebody who was in an accident? And you're entitled to that same treatment.
Well, and what's interesting, and I mentioned at the beginning of the show, the 11th Circuit opinion, which is kind of a well-known case in our circuit that applies to Alabama and Georgia. In that case, which is the case of the nurse that wanted to separate herself from the HIV role that she played at her hospital. The interesting thing about that case is the result is inconsistent with what I thought would have been reached, but there's no reason for that. There was not a requirement that the hospital provide a totally different, a different segregated environment for her. They did not have an obligation and responsibility to create a job for her. And so the 11th Circuit really protected the employer hospital in that circumstance, which is unique, and that's kind of what you're going back to. If your job is not consistently making accommodations for somebody, they're not providing extra time off for certain sectors of the employer's business, they don't have an obligation to do that necessarily just because you're pregnant.
Correct. I handled a case a few years ago where my client worked in a job where she would be exposed consistently to chemicals that could cause problems with her pregnancy and even could induce a miscarriage. She engaged in a dialogue with her employer, but the employer was not obligated to create a new position for her.
We're close, we're right around a question that someone sent in. If I'm pregnant, can I have a physically demanding job? Can I get fired? We're kind of right around that question. I think the answer would be probably no just for that, but at the same time, if it's a physically demanding job, must they accommodate that? So kind of answer the question, but also the kind of the issues around that as well.
The first question is going to be, can you do the job? If you can't, then can they provide a reasonable accommodation that's not going to create a hardship? A reasonable accommodation might be slight modification of job duties, modification of schedule. If it requires creating an entirely different job, more than likely they're not going to be required to do that unless they have done that for other employees.
Right.
Again, the key here is consistency. The purpose of this law is to say just because you're pregnant, you don't get special treatment. You just can't be treated differently or worse than anyone else. And so that's the question you've got to ask is, if somebody else was in a position where physically they couldn't do this job, would the employer work with them? If the employer would, then they should work with the pregnant employee. If the employer doesn't, then the employer's not required to work with the pregnant employee.
Can an employer force your medical leave time?
That is a hotly contested issue right now. Arguably no, because the point of your Family Medical Leave Act time is for you to take time for one of these protected reasons, or because you're unable to work. If they're forcing you to take the time and it doesn't come to one of those reasons, then they're forcing you to run out of that time faster, and so they're interfering with your right to have that time when you need it. So some employers may try, but that would violate the Family Medical Leave Act. If you came in and said, I'm pregnant, but I can still do my job, and they said, you've got to go on FMLA leave, you would have a claim for violation of that.
I know we're about to go to break. When we get back, I want to talk about how these cases are handled. If there's somebody sitting there thinking, I think that this may apply to me, I want Heather to be able to talk about how these cases are taken, how they're evaluated, how they're litigated, for the benefit of the employee that needs the help. And so we'll talk about that when we get back.
We'll do that. We'll step aside right here. Reminder, would love for you to join the conversation. This is our final break, so now's the time. If you have a question for us, call, text, email, join the conversation. You can also find the firm of Hollis Wright on Facebook as well as Twitter. Stay tuned. The final segment of The Attorneys coming right up.
I'm Josh Firth with the law firm of Hollis Wright. When it comes to a lawsuit against medical professionals, it may seem like the law favors the medical community over the injured patient, and in many ways it does. While not every bad medical outcome is malpractice, it's important to know what obstacles you may face if you're injured as a result of poor medical care. So in tonight's Legal 411, we're answering the question, does medical malpractice really exist? The answer is yes, but if something is ruled malpractice, Alabama law limits the amount of information that can be presented to a jury about a doctor. Medical malpractice is defined as a doctor's failure to use the degree of care and skill that a physician or surgeon in the same specialty would use under similar circumstances. For example, a surgeon can only be judged by the standards for a surgeon, a dermatologist by the standards for a dermatologist. These standards and the evidence that goes to a jury are controlled by Alabama statute, which is called the Medical Liability Act. This act prevents juries from hearing about a doctor's past mistakes or malpractice issues, limits the scope of information available to the injured party, and prevents any mention of liability insurance, which would pay a judgment, the very point of malpractice insurance in the first place. However, even with these restrictions, malpractice cases can still be won. The law does protect both parties and provides access to the jury system for people who have been injured after poor medical treatment. That's why it's so important to get legal help quickly if you face this situation. Please remember, your call, email, or text to the attorneys is always free. All of us at Hollis Wright want to help answer the questions you face on real issues every day. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys, the final segment of the attorneys discussing pregnancy discrimination tonight. So if you want to join the conversation, just a few minutes remaining, get those questions in by phone, text, or email. Would love to hear from you. Josh?
So when we went to break, Heather, we were talking about this concept of what does somebody do if they think that they have been discriminated against? How do they get to a lawyer? How does the lawyer handle the case? Talk a little bit about that, because I think that's important for people to recognize that it doesn't necessarily cost them money in order to come to a lawyer like you to litigate a case like this.
Absolutely. The first thing you want to do is don't delay. You only have 180 days from the date of discrimination to initiate an administrative complaint with the Equal Employment Opportunity Commission, which is the first step in any type of legal claim for pregnancy discrimination. So you don't have a lot of time. Immediately call a lawyer. Almost every lawyer is going to handle this type of case on a contingency basis, which means they will be paid a portion of the outcome if the case is successful, but you wouldn't pay anything on the front end. And almost every lawyer is going to give you a free initial consultation. The only thing you have to lose is the time that you spend on that phone call to the lawyer to ask those questions. But you want to move quickly. The first step will be to file that EEOC charge, and then after that, the EEOC will complete its investigation and issue what's called a notice of right to sue, and then you can go to court. The Family Medical Leave Act doesn't require you to go through the EEOC, but you still don't want to delay. When you're dealing with situations where you may be losing a job or off work because of pregnancy or medical issues, one of your primary concerns is you're going to lose your insurance. And so moving faster is better because you don't want to start incurring those medical bills and then having to face bankruptcy, which I guess would be another show. Yeah,
a whole nother show, or a couple shows. So under the Family Medical Leave Act, how long does somebody have to file a suit?
There's a 2 to 3 year statute of limitations. 2 years for a standard violation, 3 years for a willful violation. A willful violation is basically the employer was aware of this law, knew what they were doing was wrong, and they did it anyway. But you don't want to run the risk of saying, well, of course this is a 3 year statute of limitations. You want to file it within the 2 years.
Now, and I know and questions that we often get are, who pays for the filing fee? Who pays for the experts? And I know you talk about contingency, right. And we sometimes, as lawyers, we deal with that so often that we kind of gloss over it and say we take it on contingency. But that really is handled by the lawyer itself. Correct.
The lawyer generally is going to pay the filing fee. It's going to advance all of the expenses or costs in the case. this is something, if you have a concern, you can always talk to your lawyer about it. You can have that dialogue and say, this is one of my concerns. But normally the lawyer will bear that cost. You may be responsible for it at the end, where the lawyer says, you're going to reimburse me for these expenses out of the recovery we obtained for you. And then at that point, that's really not bad. You got an interest-free loan.
Mm-hmm. Where do you see this law going from here? Is it expanding monthly, yearly? I mean, is it getting better for the employer? Is it getting better for the pregnant worker? What are you seeing?
I think as far as the FMLA and the PDA, we're seeing both expanding. The FMLA was recently expanded to include different protections for military leave, people who need to go spend time with family members that are recovering from military-related injuries or that are on furlough. So we're seeing those expansions. There's talk about even more paid leave under that act. I doubt that will happen. The same thing with the Pregnancy Discrimination Act. While that law is fairly static in the way that it's been written, what we saw from the Supreme Court this year is that where the law had been taking a more employer-friendly swing, it's starting to take a more employee-friendly swing. And so I think as we see that, we're going to see more and more employee protections.
Talk just quickly about reproductive issues. Can employer force certain reproductive issues? I know this sounds crazy, but I'm sure it's done out there where they say, you must be on birth control if you work at this plant or at this location. Can they force those types of things?
If they did, that would run into the Pregnancy Discrimination Act. An employer cannot direct where you're going to go in terms of your reproductive health. And there are a lot of issues that come up with, my insurance doesn't cover birth control. We've heard about that big sort of fight. And that comes under the Pregnancy Discrimination Act as well. But your body is your body, and your employer cannot direct. You have to refrain from having a child.
Quickly, what do you advise women whenever they find out they're pregnant? How soon do you advise them to let HR know? Because at some point there will be a leave taken, but how much of that?
The Family Medical Leave Act says you need to request leave within 30 days or as soon as practical. At the time you start announcing your pregnancy to friends and family, that's probably the time you want to go to your employer to give them enough notice and to make enough time to plan.
Okay. Just about 2 minutes remaining, time enough just for a final thought, and Heather, we'll let you go first.
The main thing is, if you have a concern that your rights may have been violated under one of these laws, call a lawyer, call my office, call Josh's office. The worst that can happen is that you spend some time on the phone and find you didn't have anything, but you don't want to let these rights slip away from you.
Yeah, and I started the show saying that she's incredible, and she is. I mean, Heather is the person. If they call me, they're going straight to Heather related to this topic. I think this is not a simple area of the law. I mean, you can't just go prosecute these claims by yourself. You want to have good counsel, competent counsel that understands the law, the changes in the law, the way that our system works. And Heather does a great job with that, so we're proud to have her on. At the end of the day, I think I know at my firm, we have what I think is a pretty liberal pregnancy policy, which gives, a lot of leave in addition to the 12 weeks that you normally would get. And I think employers recognize they can market themselves a little bit better if they have a better pregnancy policy and encourage children. But you shouldn't feel bad. If you're pregnant, that's a like you said, bundle of joy. That's a wonderful moment. You shouldn't feel bad to go to your employer to make sure that they understand what the next step is. Right. And if the employer is not capable and willing to handle it, then there are legal ramifications for that. So my advice would be to let your employer know. And if you feel like you've been discriminated against, let one of us know, and we'll find somebody to help answer some questions for you.
Good place to end it right there. We appreciate you all being with us tonight, and you as well. Thanks so much for joining us here on The Attorneys. As we wrap things up, here's how you can continue to get in touch with the firm of Hollis Wright. Call, text, email. Also, again, find them on Facebook and Twitter. We appreciate you being with us, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.